welcome everyone. Thank you again for joining. What I will say is, I know my name's Carrie, by the way, from Morris Solicitors. One, I normally have IT issues, so apologies in advance. And two, I'm not sure if the fire alarm's going to go off, so again, apologies. Please do note my email address, though. I know there's going to be Q&As at the end, but if you think I need more information about that, or I didn't cover something, which I'm sure I will miss something, just get in touch and I'm happy to discuss with you further. So obviously the point of today's talk is contested probate, what it is, how to potentially avoid your will being or estate being challenged in the future, and why it's on the rise, basically. Just going to change my slide. Yeah, so a little bit about what I'll be discussing on the screen, but I think first of all I'll just explain a bit about Morris Solicitors. We're a trade union firm. We've been around over 140 years now. We do a range of law, including personal injury, all the way through to employment law, and of course dispute resolution, which I think somebody's just pointed out is a bit of an umbrella term for a lot of different things. Not that I'm a jack of all trades, but it is like breach of contract, debt recovery, consumer rights, and of course Inheritance Act claims, which is what this is about. So what is a contested probate claim? It's known as an Inheritance Act claim, and it's governed by the Inheritance Provision for Family Independence Act 1975. So in terms of statute, it's relatively modern, considering the Wills Act is from like 1800 and something, and probably could do with updating quite soon.
Carrie, can you say that again? It's called an inheritance.
Oh, sorry. It's the Inheritance Provision of Family Independence Act 1975. So that's the law that governs people making these Inheritance Act claims or contesting a will. And it's where certain people can challenge the will, and that could be the validity or how the will dictates how the estate's distributed and who gets what and how much somebody gets compared to somebody else. Straightforward is the wrong word, but what I'd like to say is the law surrounding it is relatively straightforward, but what is complicated is that, you know, families are torn apart. There's such emotional involvement in this that it can take months, if not years, to resolve. Because of the emotion and stress put on the family when somebody challenges an estate. And I'll be talking about challenging a will a lot, but it also covers if somebody dies intestate, i.e. without a will, and they get the letters of administration, it's still the same route. It's just somebody dies with a will or somebody dies without a will. When it comes to bringing a claim, there's a certain criteria that needs to be met. It can't just be anybody challenging a will, like Joe Bloggs down the road decides that he wants something from your estate. There's certain people that can bring a claim, and that can be a spouse or civil partner, somebody who's been living as a married couple for 2 years prior to the deceased dying, children of the estate or children of the deceased, and someone who was treated as a child of the deceased, for example, a foster child or a stepchild that was maintained by them. When bringing a claim, you first look to whether the will was valid. So was it executed properly? And I don't know how much people know about that. So, for example, it needs 2 signatures. Was the person making the will under duress when it was made? Did they feel pressure to put certain things in the will they wouldn't usually have put in the will? And did that person making the will have mental capacity? Once that's done, you'd need to deal with how the estate's been distributed, who gets what, and is it fair, essentially. Once they can show that they have standing to make a claim, for example, a child of the deceased or the spouse, then the court essentially takes a two-step approach in how they would decide if a person should be able to get something from the estate. And this is, I know it sounds like rambling, but this is why the steps to making a claim are relatively in law quite simple. If you can see, I'm sort of going down a process of what we need to look at to bring a claim. So the two-step approach, or the two questions that a court would ask is, firstly, the threshold question. So, has the will made reasonable financial provision for the claimant? And if that's answered, then the second test or the second question would be the provision question. If it hasn't, so if the will hasn't made reasonable financial provision, should it? And if that's established and the court says yeah to those two questions, then it's simply a case of calculating what would be reasonable for the claimant to get from the estate. And now I say simple, but then you've got litigation, negotiation, arguing about, well, how much should this person get? A case I've had is so there's an estate worth about £500,000. The husband dies. He owned the house. In his will, he left his wife a life interest in the property and a lump sum, a large lump sum. I think it was about £50,000, which seems quite a lot. It seems quite reasonable. However, the spouse has advancing Alzheimer's, and therefore her care needs and maintenance needs are more than that of somebody who didn't have a disease such as that. So she'll need a care home. She'll need additional medication, and so she is bringing a claim against the estate for her maintenance. And then there's an argument about how much would be reasonable. And that's how it works, really, in disputes like that. Another example is Liam Payne, the One Direction singer who sadly passed away last year. His girlfriend could potentially bring a claim under the Act. They lived, well, according to the news, so I'm not sure this is right, but they lived together as husband and wife 2 years prior to the death, and allegedly he paid her a lump sum every month. So she does qualify to bring a claim. Whether it would be successful or not is a matter for the court or for negotiation between the parties, but that's an example of somebody who could bring a claim against an estate. And when I say being maintained, I don't necessarily mean in terms of money, for example, being given a lump sum every month. It could be somebody was helping you out with your bills, somebody was helping you out with medical care, or even paying for clothing. You were in some way being maintained by the deceased before they died. I'm just quite impressed that I'm getting my slideshow to work while I'm doing this. I was saying before how bad I am at IT. Anyway, yeah, so there's been a huge increase in Inheritance Act claims. I won't repeat the figures on the screen, but it's vast, and that's very recent. You know, one of the reasons suggested, and it's quite crude, but essentially people are living longer, so people are getting their inheritance later. So then there's more questions of, well, was the will valid? Did they have mental capacity? And these are all relatively difficult things to prove, because even somebody with dementia, for example, is still classed as having, or can still be classed as having, mental capacity, and therefore the will would be valid. And then how would you go about proving somebody didn't have mental capacity after they've died? So these are all very complicated things that would require experts and long settlement negotiations, and all the while, I'll go into finances, but all the while the money in the pot is going down on legal fees. There's also cases of forgery. I've had a case whereby somebody's forged a will, and that required handwriting experts to determine was the signature the deceased or not. I'll go on to forgery in a minute, because I've got a relative, I mean, it's not funny, but a relatively awkward case, I suppose. later on. Another thing is blended families and remarriages. So, for example, somebody dies and he leaves his children more than his stepchildren, then the stepchildren try and make a claim against the estate because they think, it's not fair, I should get more. And so, like I said there, the complex family structures means more Inheritance Act claims. And I've also found that the larger the estate, the more likely it is somebody's going to try and make a claim against it. So just moving on from what I was saying or adding to it, I suppose, is the arguments that are caused by what's in the estate, who was promised what. There's already, I've mentioned the validity of the will, mental capacity, undue influence or duress, whereby somebody might abusive, I don't know, a husband and wife in an abusive relationship, somebody's too scared not to put in a will what they'd want to put in. And it's very upsetting for all the families involved. Families that have been close suddenly are torn apart, and it's a very stressful situation, which is why, going back to before, the law surrounding it isn't necessarily difficult, but the upset caused is devastating. Moving on to the forgery point, there was a case, I think it was last year or the year before. A lady forged a will, making herself the sole beneficiary of a £4 million estate. The deceased was her teacher from about 15-20 years ago. So she forged a will, signed it pretending to be the deceased, and got her two friends to witness it. And now, when the will was presented to the family, they were obviously a little bit surprised by this, considering, this lady's left £4 million to her student she probably hasn't seen for 15-20 years, challenged it and won. And not only was that a civil case, but criminal sanctions were imposed, and the woman got 6 years in prison, I think. So that was a bit of an extreme example of what forgery can be, but it shows people still do it and try and get away with it today. And the other point being, had the family not challenged the will, she may have got away with it. So it isn't just a case of people trying to get more money or saying it's unfair. There's valid reasons why people challenge wills and make Inheritance Act claims, and that's one of them. Preventing disputes. This one's a little bit of if somebody can bring a claim, so for example, the spouse or child of the deceased, there's nothing that can prevent them bringing a claim because they're allowed to, but you can do things to try and stop them challenging the will after you die. And that could be open and honest with family members and friends who are going to be in the will. Tell them what your future plans are, and explain why. Sometimes this can be a little bit difficult because of things like abusive relationships or just being scared of upsetting somebody. I've had cases where a mother has not left things equally between her adult children, and she had valid reasons for it, but she was too scared to tell them when she was alive. Had she have done, it could potentially have prevented the claim from being brought because the children would have understood her reasonings behind it, but they didn't, so a claim was brought. Other things is use a solicitor. A lot of people use or make post office wills, or they buy them online, and that causes so many problems. It brings into question the validity of the will. I've had it before whereby a husband and wife had tried to do mirror wills. So even though they were mirroring each other. They have to be two separate wills in order to be valid. They drafted theirs on one sheet of paper and signed it on one sheet of paper. Therefore, the will wasn't valid. Probate registry rejected it, and it fell into the intestacy rules. So the people who they intended to leave gifts or legacies for, it didn't go to them. It fell under the intestacy rules and went to somebody else. So it's really important to use a solicitor who's going to make sure the will is valid. Another thing that you could do is, when you are making your will, go alone. Brings into question undue influence and duress. If somebody's with you, were they influencing you to put something in your will that you didn't want to put in? Another case I've had is somebody's bringing a claim against the estate and I'm acting for the defendant, and I've made a request for the file of papers for when the deceased made her will, which showed a file note saying she was by herself and these were her instructions, which of course helps the defence. Something else to help prevent a dispute later on would be write a letter of explanation which can be read alongside the will. So you've probably all got wills, or you've at least seen a will. It's quite a, this, but you don't go into an explanation as to why you're leaving this. If you have an explanation or a letter of wishes alongside the will, it gives some understanding to the people or the beneficiaries, the executors, why you've done this. And that helps. It doesn't stop a claim, but it will help defend it should one arise later on. Basically, transparency and professional guidance is key. You can't stop it, but you can do things to try and prevent it in future. If you're facing a challenge, or if somebody you know is facing a challenge, like I've said before, it's devastating. Not only is somebody you love passed away, you're probably trying to sort probate, and then all of a sudden you're getting questions about the estate or even a letter of claim. It's hard to see straight in those circumstances. So instructing a solicitor is probably the best course of action, because not only are you getting you're giving instructions, you're getting the advice, and they're sorting the sort of legal steps, if you like, but also they're taking an objective approach. They don't have the emotional distress that you're going through. They can look at it objectively, as a solicitor would do with any claim, but it's really important to do so in these sort of challenges. And yeah, stay calm, which is easier said than done, if you've ever been through anything like that. So obviously I've spoken about the emotional impact and the stress it can have on people. I've been doing this a while, and it really does break families. People who were close a few months ago now no longer speak. It's not just a financial burden, it really does fracture families. But obviously the financial side of things is important. With these types of claims, usually the costs are borne from the estate itself. So the legal costs for both parties will be paid from the estate. In some circumstances, a judge will say each party bear their own costs, but it's unlikely. But it's something to think about, because if you've got an estate worth, let's say, £400,000, and again, an estate is everything in the pot, so the houses, savings, that kind of thing. Once litigation starts, and as it proceeds, that £400,000 could easily turn to £150,000. It's so expensive. There are solicitors' fees, barristers' fees, possibly expert fees like the handwriting expert, mental capacity reports, and court fees, mediation. It all goes down, and all the while the pot is getting less and less and less. So in way, it's early resolution is always encouraged, even if you think you're bang to rights and you're going to defend this claim, or you're the claimant, you think you're definitely going to get something. Early offers are encouraged, mediation is encouraged, just to try and settle it early so you're not constantly having these fees. Another thing to think about is some firms don't offer deferred payment, and that means that you'd pay the legal fees at the end of the case when it's all sorted. And if they don't do that, you're having to pay out these fees as you go along. And you know, a lot of people can't do that. I wouldn't be able to do that. So it's just something to think about. It's not just the emotional stress, it's the financial burden of these types of claims as well, which it's not a quick fix. They can go on years. And so it's, yeah, emotional stress and financial burden it's a lot.